Hello everyone. In today's lecture, we will be covering the topic land acquisition in India. We will try to understand eminent domain, evolution of legislation, and the current issues and challenges being faced. Coming to the contents of this lecture, we will first understand land acquisition and then the concept of eminent domain. We will proceed to look at pre-colonial and post-independence legislations, followed by the impact of the latest legislation. To start with, what land acquisition means. As the name suggests, land acquisition is a process or an act of getting private land, that is land owned by the laypersons, exercised by the government, to be utilized for a public purpose. Legislations in most countries mandate the governments to carry out development work, including infrastructure development, such as constructing roads, playgrounds, hospitals, and schools, etc. We have learned in previous modules that land serves various purposes. It acts as a shelter for someone while being a source of primary or secondary income for the other. Taking land directly from them prevents the landowners from using their land as a shelter or as a source of income. The phenomenon of acquiring land by governments has social, economic, as well as political repercussions. Now, let's discuss the concept of eminent domain, that is also known as compulsory purchase or expropriation. The doctrine of eminent domain refers to the power of governments to acquire private property for a public purpose. The expression eminent domain means permanent or eminent dominion or domain of the state on property. Eminent domain is also based on two precepts, namely, number one, the welfare of people is the paramount law, and number two, public necessity is greater than the private necessity. Additionally, according to Encyclopedia Britannica, the authority of the federal state and local governments to take private property for public use and providing just compensation to the owner is called eminent domain. As we have already discussed, eminent domain is a legal framework through which a government acquires the power to grab land for a public purpose. Eminent domain has continuously received criticism as it snatches a person's right to land and property. However, there is justification for this power when public need is considered more important than the interests of those who own the land. Important aspects of eminent domain framework are: number one, public purpose; number two, fair compensation; number three, consent of the landowner; and number four, due process. Now that we have looked at eminent domain, what it means, and what are its important features, let's look at its usage. Its use became a crucial component in urban laws and planning, but the perception of eminent domain started changing in the early 1980s because of the high social costs. Social cost in terms of the following. Number one, land is taken with low or no compensation and people are forced to leave the place they inhabit. Number two, expropriation procedures may result in high costs to society as a whole when governments are forced to pay huge sums to landowners. The evolution of eminent domain in India reflects a journey from the disorderly framework of 1894 through its misuse during land redistribution in the 1950s, the removal of the right to property as a fundamental right, to the emergence of more balanced laws aimed at safeguarding the interests of affected individuals. The Constitution of India also played an important role in determining the scope and application of the doctrine of eminent domain. These are some of the relevant constitutional provisions. Earlier, Article 19(1)(f) ensured a person's right against property remains protected, and Article 31 guaranteed the right to property as a fundamental right. However, it was repealed in 1978 and replaced by the Article 300A. Article 300A states that no one can be deprived of their property without the authority of law, and states must provide compensation if it acquires private property. Hence, right to property is a legal right and not a fundamental right. Article 300A also provides for the doctrine of eminent domain by implicitly validating the state's power to acquire private property. Now that we have discussed land acquisition and eminent domain, let's trace the evolution of legislations in the pre- and post-independence periods. The Bengal Regulation 1 of 1824 is one of the earliest pieces of legislation in the pre-independence period, which enabled government officials to obtain at fair valuation land or other immovable property required for roads, canals, and other public purposes. This particular act gave the East India Company the right to acquire private property at a time when it only had the right to tax, draw revenue, and trade. Let's also look at the land acquisition laws in different presidencies. First, Calcutta Presidency. With the expansion of the railway, the British passed Act 1 of 1850 to extend the provision of land acquisition law to the whole town of Calcutta, enabling the East India Company to acquire private property for public purposes on behalf of private companies. Now, let's look at the case of the Bombay Presidency. The Building Act 28 of 1839 was enacted as land acquisition legislation for widening and construction of roads and drains. The Railway Act 17 of 1850 was enacted in order to facilitate the transfer of land to the Railway Authority. With growing industrialization levels, all the land acquisition provisions in British India were consolidated and merged into the Act 6 of 1857 for obtaining land for public purposes and for determining the amount of compensation. The 1857 law evolved into the Land Acquisition Law of 1870. This law had a provision for independent assessors to be appointed by the state. However, the act was repealed due to delaying procedures and exclusion of the landowners from the right to object in the matter. Further, the Land Acquisition Act of 1894 allowed not only government or public authority to obtain land, but also private entities to acquire land to use it for public purposes. Some specific examples of public purpose were mentioned in the law, such as town or rural planning, providing residences to the poor and landless persons, carrying out any educational, housing, health, or some clearance schemes sponsored by the government. This act also provided for the acquisition of land for the construction of buildings for a company which is engaged in any industry that is for public purpose. The act had a controversial emergency clause to speed up the acquisition process. If the emergency clause is evoked, the collector could take any land for a public purpose and ownership would be transferred with no encumbrances. Under this clause, the landowner was not able to object in the court. This act failed to address some important issues such as the definition of public purpose, widespread misuse of the urgency clause, compensation, and lack of transparency in the acquisition process. This act caused displacement of communities and loss of livelihood. The discontent arising from inadequate compensation for land given by the British during the colonial period and displacement of the rural population set the tone of the discussion on land acquisition when India gained independence. Now that we have discussed land acquisition laws before independence, let's look at how this changed after 1947. The Colonial Act continued even after independence, and the Indian Constitution did not bring any significant change. A large number of infrastructure and industrial projects were developed after independence using the Land Acquisition Law of 1894. Land Acquisition Amendment Acts in 1962 validated acquisitions made under the Land Acquisition Act of 1894, including acquiring land for public companies engaged in public purpose related work. The 1984 amendment reduced the declaration period and allocated a timeline to make an award. It also allowed to take land for planned development and its sale to private enterprises. Eventually, the 74th Amendment to the Constitution granted decision-making powers to the Gram Sabha in tribal regions. In contrast, the Land Acquisition Amendment Bill 1998 aimed to speed up land acquisition by vesting powers in the district collector, thereby denying tribals displaced due to acquisition any say in the development process, granting the collector significant authority in land acquisition and compensation, while limiting affected individuals' rights, including inadequate notice, reduced objection periods, and restricted access to legal recourse, with no provision for prior compensation. The 2007 amendment provided for rehabilitation and resettlement scheme or plan for affected families due to land acquisition and preparation of social impact assessment report. However, there was no provision of consultation with the affected families. Due to these reasons, since the 1990s, there has been a severe outrage regarding transparency in land acquisitions and subsequent land conflicts, translating into the amendments in Land Acquisition Act 2007, followed by attempts since 2011 to repeal and replace the Act. All these efforts eventually culminated in the passage of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. This act can be seen as an attempt to create a comprehensive framework for land acquisition, rehabilitation, and resettlement, recognizing multiple actors involved and the requirement of land for development. The RFCT LARR Act 2013 requires consent of 70% affected families in case of government projects and 80% households in case of private projects. It has broadened the definition of affected persons. The compensation has to be between 2x to 4x of the market value of the land. Social impact assessment has been made mandatory. There are detailed provisions for resettlement and rehabilitation. The Act also provides a detailed and comprehensive list of what kind of projects constitute public purpose. The tables in the next two slides detail the differences between the 1984 and 2013 Acts pertaining to land acquisition laws. These also trace the evolution of land acquisition legislation in India based on the criteria listed in the first column in the tables. The 1894 Act defines the persons of interests as those who are title holders, whereas the RFCT LARR Act of 2013 defines them as livelihood losers. While the 1894 Act is ambiguous regarding the public purpose, the 2013 Act defines public purpose in a clear and detailed manner. Under the 1894 Act, land could be acquired coercively. However, the 2013 Act makes consent as well as social impact assessment mandatory. There was rampant misuse of the urgency clause in 1894 Act, whereas the 2013 Act clearly defines criteria for invoking the urgency clause. It is to be noted that the urgency clause is to be invoked in situations involving India's defense, national security, or for emergencies due to natural calamities. In 1894 Act, the compensation was subject to the discretion of the project implementer. However, the 2013 Act mandates 2 times average value of the registered sale deeds in rural areas and 4 times average value of the registered sale deeds in the urban areas. Rehabilitation and Resettlement Award also includes provision for constructed houses in place of the house lost through acquisition of land. In some situations, the Act also provides for the grant of land in place of the land acquired. While there was no provision for dispute resolution in the 1894 Act, the 2013 Act directs the state governments to set up dispute settlement authorities. There was no security given to the fertile lands under the 1894 Act. However, as per the RFCT LARR of 2013, fertile land, including irrigated land and multi-crop land, can only be acquired as the last resort. In case of acquisition of multi-cropped and irrigated land, an equivalent area of cultivable wasteland must be developed to compensate for the loss of fertile land. Lastly, there was no provision for returning the land in case of stalled project in the 1894 legislation. However, the RFCT LARR says that if land remains unutilized for a period of 5 years, then it should be returned to the owner. Because of the implementation of the 2013 Act, landowners did receive compensation amounts significantly higher than under the previous laws. For many, the rehabilitation and resettlement provisions offered employment opportunities, alternative housing, and monetary benefits, enhancing their social and economic status after displacement. The consent and transparency requirements reduced cases of land being forcibly acquired without a fair hearing or just compensation. However, this act faced criticism by state governments and industries on the grounds that the act will stall all land acquisitions by making acquisition costly and the associated procedure cumbersome. LARR Amendment Ordinance in 2014 exempted 5 categories, that is defense, rural infrastructure, affordable housing, industrial corridors, and infrastructure projects including public-private partnership from consent and social impact assessment provisions. The ordinance was challenged in 2015 in the Supreme Court on grounds of misuse of power by the government. In the same year, the Vice Chairman of the Niti Aayog suggested that in the absence of parliamentary consensus, state governments should go ahead with state legislature amendments to the 2013 law. In 2016, Gujarat and Rajasthan, and in 2017, Maharashtra, Telangana, and Jharkhand amended the RFCT LARR Act to substantially incorporate the provisions of the lapsed central ordinance. Moving on to discuss the challenges with respect to the RFCT LARR Act of 2013. Number 1. Social impact assessments and obtaining consent. Provision of impact assessment and obtaining 70 to 80% consent of owners has delayed their implementation. Number 2. Inadequate resettlement. The Act does talk about rehabilitation, but the implementation is very slow, with huge time lapse in procuring homes and sources of income for the displaced families. Number 3. Compensation and valuation concerns. Land market fluctuation makes compensation determination unpredictable, due to which there are administrative delays in the payment of compensation. Number 4. Effective implementation of the RFCT LARR Act needs administrative reforms such as enhanced state capacity, accurate land records, and compliance with the procedural requirements to ensure equity and efficiency in land acquisition. So far, we have traced the progression of land acquisition with respect to various constitutional and legislative provisions. Now, let's have a look at what proposed alternatives are there to land acquisition. Firstly, land pooling and readjustments. Under this, the landowners contribute their land to a common pool for development, and after infrastructure improvements, a portion is returned to them, typically at a higher value. Second are land banks. Under this, the government or agencies acquire and hold land in advance for future development projects, reducing the need for reactive acquisitions. Third, we have the instrument of the Transferable Development Rights or TDR. Landowners receive development rights in exchange for land, allowing them to use or sell these rights elsewhere for monetary or developmental benefits. Fourth is direct purchase at market rate. Land is bought directly from the owners at prevailing market prices, often through mutual negotiation without invoking land acquisition laws. Now, let me sum up this presentation. In this lecture, we delved into the historical evolution of land acquisition laws and examined how colonial era policies shaped current practices. After understanding more about the land acquisition laws, it can be said that the land acquisition framework in India highlights the conflict between property rights and the need for land for economic development. We also reviewed the existing legislation, namely the right to fair compensation and transparency in Land Acquisition, Resettlement and Rehabilitation Act of 2013, and how this act addressed issues in the colonial laws. Additionally, we were able to enlist the challenges in land acquisition even after the passage of the Act of 2013. Thus, it's clear that without key administrative reforms, seamless land acquisition process cannot be achieved in a country of vast size and complexities like India. That's all for today. Thank you very much.